SJC-12404, Commonwealth v. Bernie Ruiz.
Mr. Shepard-Brick, good morning.
May it please the Court, David Shepard-Brick on behalf of the Commonwealth. The habitual criminal law of 1832 and 1833 required separate sequential prosecutions with an intervening period of liberty. No other version of the statute has had such requirement, and the legislature has shown itself more than capable of adding this requirement if it wants to. The defendant suggests that there is an ambiguity in this statute such that the rule of lenity should favor his interpretation. I would suggest that argument is specious because it ignores the plain and ordinary meaning of twice convicted and sentenced. The appeals court, in fact, has already addressed this very issue in Commonwealth v. Hall and Commonwealth v. Keene, both relying on this court's decision in Commonwealth v. Phillips, which established that under statutory language very similar to this, the two prior convictions need only arise out of separate and distinct criminal episodes, but they can be resolved together in one term of court.
Does the language in 25B, where they actually precisely point that out, speak to the interpretation of 25A?
Well, it would, I think, in part, but this court in Commonwealth v. Garvey sort of rejected or explicitly rejected the maxim of negative implication for arising out of separate and distinct criminal episodes because the legislature had not substantially revised 25A. It appears the only change that they made in 25A from the 1904 version to the 2012 version, there was a minor language change, and they removed the requirement that the prior sentences be committed. So now they only have to be convicted and sentenced. There is no requirement that they actually serve any portion of that, so suspended sentences would apply. But there otherwise was no change, which suggests that the legislature was happy with the interpretation, which, going back to Richardson, has been two convictions arising out of separate and distinct criminal episodes qualify for the statute, regardless of whether or not they were resolved together.
Let me make sure I understand your position. Let's imagine a scenario that is not here, okay? And let's imagine that a person is charged with 3 separate robberies on different days, 3 separate indictments. It is not your view, I think, that after being found, after pleading to all 3 and getting 3 years on the first and 3-year concurrent on the second, that the judge then is obligated for the third to give a habitual sentence.
No, that is not my argument, because it does say previously twice convicted and sentenced.
Okay. So your position is that, which is the situation here, if there are 2 separate events, 2 separate indictments, 2 separate convictions, 3 years on each, I forget whether the second is concurrent or not, but you're saying it doesn't matter,
right.
that at that point, having had 2 separate convictions, you are on notice that if convicted again on the third, you'll be a habitual criminal. That's
correct, and this court in Richardson made note that to the extent that the law required the conviction, the two prior convictions to be separate from the third conviction, it said that was most likely a requirement, that they had the 2 prior convictions, the defendant had to have been committed on those terms, on those counts before committing the third offense. But the court was very clear that it said the implication went no further on that point.
So let's assume for the moment you're right. Not really before us now, but should we, as a matter of fairness, then include that as part of the colloquy for the plea? That now, with your second conviction, the next time you would be a habitual? So that's something we should give warning to?
Well, I mean, the legislature has certainly expressed a preference in the latter sections, I think it's 25D, that individuals be warned about their exposure as a habitual criminal. So I don't think that there's any good reason not to give fair warning. I don't think it should invalidate an otherwise lawful plea, which the legislature also specifically put in Section 25, that failure to give the warning does not invalidate an otherwise lawful plea. But I don't think there's anything wrong or improper about warning the defendant in open court.
But I gather it's not required currently by our Rule 12.
It's not required by Rule 12. I'm not sure. It is required by the statute. It may be required by Rule 12.
Okay.
So-
I'm sorry.
No, please, Chief. Okay. So, sort of draconian, if you look at the name of the section, it says habitual offenders. And if you've been found guilty at one prior proceeding where you've pled guilty to 2 robberies on 2 different dates, and then X amount of years later, you're charged, you're facing 25A. And the title is habitual offender, and then the first line says, previously twice convicted and sentenced to state prison. Is there any suggestion that twice convicted and sentenced suggests 2 separate sentencing, and if not, why not?
Well, I would suggest first in one prior sentencing hearing, there are 2 convictions and 2 distinct sentences. I mean, this was a case where the defendant received a 5 to 7 year prison sentence on counts, or I think maybe it was 4 to 6, on counts 1, 6, and 7. And when imposing sentences, a judge reads out each sentence on each count, and the minimus reflects I don't know in this case, but generally speaking, they reflect each sentence the defendant is given. So I would suggest that that is 2 separate or 2 sentences. You have to read language into the statute to require that they be separate. And the legislature said in 1832, 2 several convictions. And in 25B, they said arising out of charges separately brought and tried, where the first offense, where the second offense occurs subsequent to the first conviction. And simply requiring them to be separate, arise out of charges separately brought and tried, would create 2 different classes of defendants in specific situations. So if you had an individual who committed a crime in Hampshire County and then committed a different crime in Hampden County, and those would arise out of charges separately brought and tried, even if their sentences were concurrent, you would treat those individuals differently than someone who committed 2 separate and distinct criminal episode crimes in a single county.
If I could turn you to the Rule 15 issue, which you
Yes.
raise in your complaint as to whether or not the Commonwealth is entitled to appeal where there is a dismissal of part of an indictment or so much of the indictment as charges habitual offender. Why should that be a Commonwealth right where it's only part of the indictment as opposed to the entire indictment?
Well, certainly the 278-28E speaks to the Commonwealth's right to appeal a dismissal. And I would suggest the Article 30 concerns are no different whether it's a partial dismissal or a full dismissal, because the judge is preempting the executive power by denying, in this case, we argue, without a lawful authority, the Commonwealth's right to move forward on that portion of the indictment. I mean, it would be the same if the judge allowed a motion to dismiss a murder indictment as so much as alleging murder in the first degree, but allowed the Commonwealth to go forward on murder in the second degree.
How about an OUI fourth and reducing it to an OUI third, the same argument?
Yeah,
And you have to prove these underlying crimes to the jury under Apprendi, right?
right.
So what we're saying when Rule 15 is unavailable is there's part of this indictment that has to be proved beyond a reasonable doubt to a jury, but try 211.3 because Rule 15 doesn't apply.
Well, right, and that's the difficulty, because there is no other remedy for the Commonwealth. Once we're precluded from moving forward on that portion of the indictment, jeopardy is attached and it's lost. I mean, that was the actual issue that in one of the issues in Commonwealth versus Phillips. In Phillips, somehow that defendant had slipped through the cracks, and they had missed the fact that he was qualified as a habitual offender. So they had tried to bring a separate indictment, and this court said, no, it's part of the third felony. It has to be brought as part of the third felony.
So your view is that whenever anybody dismisses so much of the indictment as charges X, that the Commonwealth would be entitled under Rule 15 to appeal?
Yeah, and again, I think it's the Article 30 concerns are the same regardless of whether it's a full dismissal or a partial dismissal.
Any limitation on its scope, because it could be a relatively trivial part of the dismissal potentially.
Well, I mean, I don't think that it's going to sort of open the floodgates to challenges. In large part, the Commonwealth is still responsible for paying the fees on any appeal, so that there are a lot of other considerations. I don't think that we'll be taking any more appeals. They're only taken when we believe it's absolutely necessary. There are no further questions. I'll rest on my brief.
Thank you.
Thank you.
Mr. Michaud, good morning.
Good morning. Attorney Patrick Michaud for the defendant. I'd like to address a few of the issues. One is with respect to the 279 Section 25A dismissal. The courts have found that sound reasoning and common sense should be applied to these statutes. And previously, twice convicted and sentenced, the defendant would suggest means that he has to have two separate cases that were tried and or pled in two separate sentences, so two separate convictions and two separate sentences. Certainly that would require the Commonwealth perhaps to more work per se.
You want two separate court dates?
Well, I want certainly some sort of notice that that these are two separate sentences and convictions for these charges. Whatever the charges may be with respect to this defendant, there were certain charges brought against him.
So to use the Chief's hypothetical, if we have someone who committed a string of armed robberies, robbed convenience stores, and he robs 3 of them, the government indicts the person, and the government says to the defendant, I know you're going to package these, but my victim's only available for robbery number 1 and 2. Let's do that plea. And they do that plea. Victim shows up to make a statement. A week later, they do plea number 3, right? In both cases, they get 3 to 3 in a day concurrent. Under your view, does that qualify?
If I heard you correctly, I believe so.
Okay, so that'd be okay.
I believe so, yes.
All right. And the fault here is that, under this hypothetical, is that they did all 3 together as opposed to a week apart.
Correct. I figured how many different months these occasions, these incidents occurred over, but there was, I believe it was several.
Because we have the separate issue, and that was Garvey. That's fine here. But we need, you think it should be more than one court event so that the defendant walks out of court and says, I better be careful. I've got strike 1. Don't get strike 2.
Well, I think either that or certainly notice that when the attempt to convict him on the second or third offense, that he's certainly on notice.
Don't they get notice from the plea colloquy?
With respect to this, I'm not sure, so I can't answer to that.
Do we have that record, by the way?
I don't believe it was included.
Is your interpretation going to make a lot of defense attorneys and defendants ultimately pretty nervous? I mean, here you got the negotiation of these, maybe a string of convenience store armed robberies, and maybe they're fueled by OxyContin or whatever it might be. And they're having this discussion, they're going to wrap all these up, and the judge is going to hear the victim impact statement all at one time. And now we're going to turn these into 3 separate hearings because of this statute, maybe 3 different judges, 3 different colloquies. Is this going to put just a chill at ground zero right through every criminal defense attorney in Superior Court?
Well, I don't know about that, but it certainly will.
I don't know, but it might.
Certainly will make for more work and bottle up some of the courts a little bit. I do agree, and certainly I agree that perhaps there could be some more clarity with respect to this statute and with respect to the first issue. So I agree with my brother that there is certainly a need for clarity.
How does this concept of providing notice fit in with the general broader concept of ignorance of the law is no excuse, and we don't warn the defendant about all of the crimes they could possibly be charged with?
No, I agree that ignorance of the law issue, but this is a pretty significant or harsh sentence that we're talking about, and that's the reason it's called a habitual offender statute. It's, and that's why we're talking about a previously twice convicted and sentenced. We're talking about a significant amount of time in jail for these actions, and I'm not suggesting that a defendant should just be able to commit a string of crimes and say, well, I was only convicted on this one date, so I can avoid this habitual offender statute. But certainly there has to be some sort of notice or idea that this significant impact is going to play out should a defendant proceed along in that fashion.
25D of the statute requires that the defendant be informed by the court.
I agree that there's some issues of clarity with respect to the statute, and that it is not.
Court shall inform the defendant that a conviction, plea of guilty for such an offense implicates the habitual offender statute. So the defendant has to be warned at the colloquy of the implications of 25A.
Correct, and I don't know. Well, in this case, that's the issue that we're dealing with is whether or not the defendant would have been on notice.
Well, the Rule 12 in the colloquy provision says that the judge shall inform that the case implicates the habitual offender statute. So if you're doing an armed robbery case and as a trial judge, and you know that the person's getting more than 3 years, it's incumbent upon the trial judge to say, by the way, one of the consequences of pleading guilty is you will now have eligibility for habitual offender. But we don't know if that happened.
I don't know if this happened in this case when the 2006, I believe. I don't know if this happened in that case at all.
And fairly, I don't know if our Rule 12 said that in 2006, which we will find out.
I'm sorry.
I don't know if our Rule 12 said that in 2006, but we'll find that out.
Yes.
The date of the instant crime was when?
November. Well, the
earlier ones were in 2006.
Correct.
When was this one?
There was 2014 and 2016 cases, and I believe this one applies to the 2016.
Okay, so it was well after. We're not the situation which Justice Gaziano mentioned, where 3 events occur and then the person is convicted, does not apply here. Here, the actual crime occurred after he was twice convicted and sentenced.
No, he was. My understanding is he's only convicted on this 2006 indictment.
I'm sorry, I thought there was an incident on 9/18/06, 7/25/06, and 8/23/06 for which he was convicted.
Oh, well, one indictment, one complaint. My understanding is there was one sentence with respect to, there was a string of offenses at different dates, different types of offenses that were all lumped into one in 2006. That's my understanding.
Right, I understand that. But this is not a situation where this is another 2006 act. The acts that occurred, the crime that he allegedly committed, occurred after he had been sentenced on these other matters.
Correct.
So
Correct.
the Justice Gaziano example suggested that the crime may have occurred before he had been twice sentenced. And
Actually, what I was discussing, the example I used, and I think you answered it, was that rather than having these three, your hypothetical, Chief, about the three, is that if they all occurred a day later, if the pleas themselves, they're separate court events as opposed to.
Right, I'm just wondering whether or not the twice sentenced and convicted means that the act must be committed. The act for which you're now subject to a third conviction must be committed after you had been sentenced on the earlier two.
I'm not sure that that would be the case, but I would also point out that the period of liberty issue, I don't think is, well, the period of liberty, I don't believe is an issue as well. I don't believe somebody has to have a period of, be sentenced, then have a period of liberty in order to have this apply. The fact that whether there's notice or not, I think is more important than a period of liberty, which again, I don't believe applies to this, because that came up in my brother's brief, which again, I agree with him, that there isn't a period of liberty issue.
So your view is that there has to be a separate sentencings?
Correct. And if there's no other questions, I would rely on the brief.
I have one further
Sure.
question. Can you tell me the difference between 25A and 25B as far as its reach?
As far as what?
You know, what does 25B cover that 25A doesn't?
That's a good question. I was not prepared to answer that, so.
I gather that 25A can be subject to parole. A 25A sentence, you can be parolable, and you can get good time, I gather, but not 25B.
I unfortunately will not be able to answer that question this morning.
Okay, I mean, 25B includes the language, no sentence imposed under this subsection shall be reduced or suspended, nor shall such person so sentence be eligible for probation, parole, work release, or furlough. And that language is not present in 25A, so I assume that language, that those conditions would not apply to 25A. I think that was briefed. So it is a harsher habitual than 25A.
And again, I would concur with my brother that there does need to be some clarity with respect to a decision here. With respect to both issues, because I do think there can be some confusion created, and to prevent further delays and bottling up the courts, certainly these issues should be resolved.
Do you agree with them that Rule 15 should be applicable?
I think as it stands, I believe that that it should not, but I do agree that there does create some more complex means of appellate procedure that probably aren't necessary and that could be eliminated.
Well, why do you say it should not apply?
With respect to, I believe that their method of under 211 Section 3 is available, and so the issue that was raised by my brother in his brief, which which I had in my appellee brief had suggested that the timing issue isn't that much lengthier in a direct appeal or appeal under 211 Section 3. But my understanding of the reading of 15A is that they don't have a right of direct appeal on a dismissal of the habitual habitual statute, habitual offender statute.
But the perspective of the single justice of whether this is extraordinary relief or whether we're under Section 28 could be dramatically different. And the Commonwealth's position is that part of the charging decision of the executive branch is just eliminated without any recourse other than is the single justice going to consider this a request for extraordinary relief?
Well, and I agree that that's a harsh result if there's a denial of that, if further appeal is denied as well. So, I agree that that's another issue that has to be some clarity on. So I think under, as the rule and the statutes stand now, that the method that it was brought forward here today is the way the case would be brought. But I do think that there should be a need, and there is some need for clarity on that. And if there's no other questions,
Well, make sure, I just want to be sure that I understand your argument. The statute says has been previously twice convicted and sentenced. Your view is that he has only been once previously convicted and sentenced because there was only one sentencing proceeding.
correct.
Okay. Thank you.
Thank you.